We are recording.
All right, good afternoon, everyone. Welcome to the Appellate Court. I am Judge Bright. I'm sitting this afternoon with Judge Prescott and Judge DiPentima on the matter of State versus Green. The AC docket number is 42975. We are conducting this hearing over the Teams platform, so everyone is appearing by video conference. In addition, this argument is being streamed live via the branch's YouTube channel. So to the extent there is any protected information that should not be disclosed, I'm going to ask counsel to remember not to disclose that type of information and be as careful as possible. I'm going to ask everybody to introduce themselves just so we can make sure we can hear and see each other okay. I'll start with the judges, then counsel for the appellant, then counsel for the appellee. Again, I'm Judge Bright.
I'm Judge Prescott.
Good afternoon, Judge DiPentima.
Good afternoon, Attorney Jay Sexton.
Good afternoon, Senior Assistant State's Attorney Melissa Strito.
All right, I can hear and see everyone okay. I'm assuming that's true of everyone else. If for whatever reason you are unable to hear anybody, please let us know. And if you're unable to see anybody, please let us know. If you get disconnected from the argument for whatever reason, please click on the link. We will suspend the argument until we have everybody present. I will ask everyone to keep their microphones muted when they're not talking so that we can avoid any background noises and avoid people talking over each other. If the judges have any questions during argument, we will raise our hands and ask counsel to recognize us. We're doing that again to avoid talking over each other. If you don't do that, though, we will just jump in like we would in the courtroom. And although I ask you to keep your microphones muted, we would ask you to keep your cameras on at all times so that we can make sure everybody is present and appropriately engaged in the argument. Each side will have 20 minutes to argue. The appellant can reserve time for rebuttal. I will keep the time and hold up signs since we don't have our light system at 2 minutes, at 1 minute, and when time is up. So with that, I believe we're ready to proceed. Attorney Sexton, are you ready to go?
I am, Your Honor. Thank you. Good afternoon. May it please the court. My name is Attorney Jay Sexton with Sexton & Company, and I am here today as assigned counsel on behalf of the defendant appellee, Courtney Green. I'd like to reserve 4 minutes for rebuttal, please.
Okay, you're all set. Go ahead.
Thank you. One quick housekeeping matter I just wanted to raise. In the first 4 pages of our reply brief, we inadvertently refer to the underlying motion as being a motion to correct an illegal sentence rather than a motion to withdraw a guilty plea. That misstatement in no way affects the legal analysis, and we apologize for any confusion. Our Supreme...
Say one other housekeeping matter, Attorney Sexton. I just want to state for the record, we received your letter dated February 28th, 2021, with 2 supplemental authorities. And I wanted to make sure that Attorney Strito had received that as well.
I did, Your Honor. Thank you.
Okay, proceed.
Thank you, Your Honor. As our Supreme Court did in State v. Reed, this court should treat this appeal as if a motion to file an untimely appeal from the defendant's 2009 assault conviction had been granted and reverse that judgment because it was predicated on the basis of an unconstitutional plea canvass. Specifically, because the trial court failed to canvass the defendant in any way regarding whether his plea was the result of force or threats or promises apart from the plea agreement, the plea was obtained in violation of due process and cannot stand. I would like to begin by addressing the elephant in the room and explain why this case presents the type of exceptional circumstances that justifies this court invoking its supervisory authority to treat this appeal as a permissible late appeal from the defendant's 2009 conviction. And when discussing the concept of exceptional circumstances, I think the term exceptional connotes at least 2 important and related concepts. First, that the circumstances have to be exceptional in the sense that the usual constitutional, statutory, and procedural safeguards have proven inadequate to ensure justice to date. But secondly, that the circumstances also have to be exceptional in the sense that they're unlikely to be replicated in future cases. And that's because, first, obviously, things that happen commonly are not exceptional. But secondly, in order to ensure that Pandora's supervisory authority box is not opened too regularly in run-of-the-mill cases, you want to make sure that indeed you have exceptional circumstances that are not commonplace. And I think that those two standards in terms of what makes circumstances exceptional were met in State v. Reed, and I think that they're met here, albeit for slightly different reasons. In State v. Reed, as here,
Counsel, why didn't you just file on behalf of your client a motion for permission to file a late appeal? And then we don't have to get into this at all.
I appreciate that, Your Honor. Part of that is because of the way that criminal appeals are handled when they come to us through the Office of the Chief Public Defender. They come to us, they automatically file the appeal before the cases are even assigned. In fact, the Public Defender's Office usually files the appeal. They file the preliminary appeal papers that are required under 63-4.
So, and you agree the trial court lacked jurisdiction over this motion, correct?
Yes, Your Honor.
Right. So rather than pursue an appeal where the trial court had no jurisdiction, there's nothing that would have prevented you from withdrawing the appeal in lieu of filing a motion for permission to file a late appeal. Agreed?
I believe that's correct, Your Honor.
So why not do it that way?
Because, Your Honor, we have State v. Reed. And at the end of the day, I think that it essentially amounts to more or less the same analysis that this court is doing. And since it came...
So let's talk a little bit about State v. Reed. In State v. Reed, the defendant did not have the option, other habeas action, because his sentence on the underlying assault conviction had expired, correct?
Yes.
So he wasn't in custody.
Correct.
He had no other options to deal with a situation where he had been wrongfully convicted of a sexual assault. And after that conviction was set aside, the prosecutor referred him back to ICE based on a conviction that happened several years earlier, right?
Okay, that is correct.
This case isn't anything like Reed on those underlying facts, is it?
I think it is. And let me explain why, Your Honor. The reason why is obviously, no, this is not a case that involves ICE. This is not a case that involved that specific set of facts. But what it does involve is a situation where after there having been a habeas on the issue of the plea canvas, it was not until that habeas got appealed to this court, and this court identified the voluntariness of the plea canvas as being problematic, that it was brought to the party's attention. And it was then that you had the unusual circumstance where Attorney Pattis.
But why couldn't you pursue a habeas against prior habeas counsel?
Your Honor, I think that goes to exactly the reference to General Statutes 52-470 sub D in our 6710 letter that we filed, because it is now beyond the 2 years. And so there's a presumption that there was not good cause for him to bring a subsequent habeas. And as I understand this court's interpretation of the good cause requirement, he would have to show not simply that he was mistaken by the law or didn't know that he had other legal remedies to pursue, rather than, say, a direct appeal or even a motion to withdraw his guilty plea in the first instance. And I think that would be difficult.
Hold on, Attorney Sexton. The 2 years under the statute would have started to run after the last appeal was finalized, right?
Yes, and that That is true. And the Supreme Court denied the petition for certification on that on June 14th, 2017, meaning that the 2 years would have closed by June 14th, 2019. The appeal in this case was filed by the Chief Public Defender's Office May 22nd of 19, and it wasn't assigned to us until after that.
But what you're saying is that, and both this answer and the answer you gave to Judge Prescott are, well, because the public defenders has this procedure in place, that causes this exceptional circumstance, when it seems to me the right way to fix it is just change the public defender's procedures.
That may be, Your Honor, but that's not the exceptional circumstance. I want to be clear that the exceptional circumstance that I believe we have in this case is twofold. It's one, that this court first identified the issue with the voluntariness of the waiver, and two, in response to that, that Attorney Pattis stated on the record, if this court agrees that that is a legitimate legal claim and that the plea canvass was invalid as a result of the lack of inquiry into voluntariness, then I would advise my client to file a habeas against me because I left something on the table. And so my point to this...
Attorney Sexton, I apologize if I didn't catch this. You are basing that whole thing about this court saying it was an inadequate canvass on a colloquy during oral argument. Is that correct?
Yes, I am, and I'm not saying that to in any way. I understand the comments made by the court during oral argument are not binding. It's certainly not a statement
not at
of
all precedential.
Of course, 100%. And I'm not relying on it to support the contention that the plea canvass was in fact a violation of the due process rights due to the lack of inquiry into voluntariness. What I am saying is that the combination of having the court issue spot that, and more significantly, Attorney Norm Pattis's response to it, where he says that if in fact this court believes that that is the case and that the plea canvass is unconstitutional as a result of that, that an ineffective assistance of counsel claim should be brought against him by his client because he would have left something on the table. So my point is that it's very rare, just like it's very rare, Judge Bright, in the case of State v. Reed, going to your original point, where you have someone whose deportation was originally predicated on one conviction and then subsequently that is swapped out for a different conviction. I think it's equally rare that you have a situation where this court identifies a potential constitutional issue and that the attorney, in response to that, in open court on the record, indicates that far from there being any strategic value to raising the issue that he did, that if in fact the legal conclusion is that it was unconstitutional, he would involve an ineffective assistance of counsel claim being brought. And my point is that however ripe it may be for OCPD to reevaluate some of the internal procedures in terms of how quickly things can be assigned, I think that the bigger issue for this court now is that under 52-470D, it seems unlikely, and certainly I think it's probably a little speculative, but that Mr. Green would be able to get a subsequent habeas at this point, meaning that we're in a situation where we have what I believe is a real constitutional error, as we argue, because there is no inquiry. This is not a situation, even
Attorney Sexton, if we get to the merits, the state cited State versus Ocasio, which was a procurement opinion by our Supreme Court. You do not mention it in your principal brief, nor do you address it in your reply brief. And
I was actually just about to mention it right now.
Okay.
And in State v. Ocasio, what you had there where the Supreme Court decided in a PC decision that all you need is substantial compliance. What State v. Ocasio had was a direct question by the court to the defendant whether or not his plea was voluntary. And that was at 253 Con at 381. And you don't even have that here. You don't even have a court asking the conclusory, question, is this voluntary without, let alone going into the various ways in which voluntariness is thought of by a court in terms of whether it's the result of duress or coercion or other inappropriate promise. So I think that I don't think that this is even a case where you can possibly call it substantial compliance when one of the primary areas that's constitutionally required by a plea canvass is absent entirely from the canvass altogether. There is no discussion of it. Forget the inquiry part. There's no mention of voluntariness or anything akin to it, and there's certainly not even what you had in Ocasio, where the court asks if the plea is voluntary. So I do think that this is a situation where you don't even have substantial compliance. We do have.
Counsel, if we declined to treat your request to treat your appeal as a motion for permission to file a late appeal, will we have necessarily abused our discretion?
I don't want to be cute, but ultimately that's going to be for the Supreme Court to decide. I mean, you know, for example, in Ramos v. Commissioner v. Correction, this court denied a motion to file a late appeal, and the Connecticut Supreme Court reversed this court and held that there was good cause, and actually said that the reason that there was good cause in that case and that this court had abused its discretion was because of the fact that, as the petitioner in that case had advised this court during a hearing, that his confusion stemmed from all of the sort of problems with the assignment of counsel by the Chief Public Defender's Office, and he had been confused, and the Supreme Court indicated that in as much as the state didn't rebut that at the hearing before this court, that this court had no reason not to believe that that was in fact the basis for it, and did reverse. So I acknowledge that it's an abuse of discretion standard, but it's overcome in some cases.
But so your argument would be, on these facts, in this case, as you've laid it out, we have no discretion, where we would abuse our discretion if we declined to your request.
I think that this case, given the unique facts that I've articulated in terms of the issue spotting of the constitutional voluntariness issue by this court, and prior habeas counsel's response to that his counsel would be ineffective, and in fact, as a matter of law, the plea canvass was constitutionally deficient on that basis. I think you do not. I think that you would not have the discretion not to take it, based particularly on State v. Reed, where you had, albeit different exceptional circumstances involving immigration issues, but which the Supreme Court used to reach the issue. So yes, I agree with you that we would not have that this court would abuse its discretion if it did not reach it. Further, Your Honor, I just wanted to additionally note, with the remaining time that I have, that that waiver cannot be presumed from a silent record. So this is unlike a case where an inadequate record means that we presume that the court did the correct thing. That is not the case where you have the full plea canvass and the canvass did not address an important issue. Additionally, as noted in State v. Gore in footnote 20, this is where you have a violation of a plea canvass. This is a structural error. In State v. Gore, it was, yes, Your Honor.
Let me ask you, if this was brought as a habeas on a habeas, would you still have to establish prejudice and convince the court that the defendant was under duress at the time?
I don't believe we would, because of the fact that this is a structural error. And I would be happy to provide a one-page supplemental authority on that and do the research. but I believe, based on recollection from cases I worked on years ago, I have a recollection, Your Honor, that, may I finish the?
Yeah, go ahead.
Thank you. I believe that there is case law that says that where the issue being litigated as part of an ineffective assistance of counsel is itself structural error, you do not need to reach the second prong of ineffective assistance, which is what you see in the chronic claims of constructive deprivation of counsel.
Okay. All right. Thank you. You'll have 4 minutes for a rebuttal. Attorney Streeter.
Good afternoon, Your Honors. May it please the court. My name is Melissa Streeto. I'm a senior assistant state's attorney on behalf of the state of Connecticut this afternoon. Your Honor, this case presents a unique circumstance in the sense that the defendant and the state agree on several key factors. We agree that the trial court lacked jurisdiction over the defendant's belated motion to withdraw his guilty plea. We agree that there was no statutory or practice book provision that would have granted the trial court continuing jurisdiction. And we agree that therefore the trial court properly dismissed that motion to withdraw for lack of jurisdiction. Where we part company is on whether, given all of the foregoing, this court lacks jurisdiction to entertain this appeal as argued by the state, or whether this court may consider the merits by exercising its supervisory authority to consider this as a late appeal, which is what the defendant has argued.
So, Attorney Streeto,
yes,
I don't completely understand. I know you cited to a footnote from the Supreme Court, but I don't understand the argument that because the Superior Court dismissed the case for lack of jurisdiction, we're deprived of jurisdiction. Because we have a judgment from the Superior Court, and typically we would have to determine whether the Superior Court properly dismissed the case. So could you explain, and like I said, I understand it's in a footnote in the Supreme Court opinion, but can you explain the rationale behind the argument that because the Superior Court lacks jurisdiction, we lack jurisdiction?
Well, two things, Your Honor. First of all, it was not only in a footnote, that footnote was in the Doss decision, but the Reed Court itself said this in the body of its decision, that whereas here a defendant seeks to challenge the trial court's dismissal of a post-sentencing motion to withdraw his plea over which the trial court lacks jurisdiction, this court also lacks jurisdiction to review the merits of the trial court's dismissal. So,
but can you explain that to me? Because I'm just having a difficult time understanding that. Because how would you ever get appellate review of whether the trial court's determination of jurisdiction was correct?
Well, because if there is no dispute that the trial court here lacked jurisdiction by both statute and practice book rule to consider the merits of the defendant's claim, because his motion to withdraw was brought many years after sentence had been executed. And so I understand what you're struggling with, because I struggle with that too, but I don't, because there's no dispute to that, then our Supreme Court has decided that this court lacks jurisdiction to consider the merits of any of the constitutional claim, I guess that would be.
Okay. So it's where the defendant does not dispute there's a lack of jurisdiction in the trial court, then we would lack jurisdiction to, in this case, exercise our supervisory authority.
Well, I don't want to get caught up in the semantics, but that's not what the Supreme Court said. It just says if a defendant is challenging this dismissal on a belated motion to withdraw a guilty plea that the trial court lacks jurisdiction over, then this court also lacks jurisdiction. I think the more important point for me is that because there is no jurisdiction for this court, then this court necessarily lacks the authority to exercise its supervisory authority to reach the merits or to consider the merits of this claim. In other words, this court may not invoke its supervisory authority to circumvent a jurisdictional bar.
Well, then how did the Supreme Court do that in Reed?
Quite frankly, Your Honor, I don't know. And if this court goes to the if this case goes to the Supreme Court, as I suspect it will, I will be arguing that that should be reconsidered and re-examined. Reed is the only case that I've been able to find, especially since Das, which expressly overruled several cases that either explicitly or implicitly kind of latched onto this notion that there is some sort of a constitutional violation exception to a jurisdictional bar. And the Das court specifically said that is absolutely untrue. We either have jurisdiction or we don't. If we don't, it's the end of the case. It must be dismissed. Yes, Your Honor.
Pretty sure. Tell me if you disagree with my kind of formulation of this. We have jurisdiction to determine whether or not the trial court had jurisdiction. You agree with that?
I would say that that's true, Your Honor.
Right. And given, and I understand your position to be that given that there's actually no controversy regarding whether or not the trial court had jurisdiction, that there's essentially nothing to decide in this appeal.
Yes, that's part of it. Yes.
All right. But we also have Reed that seems to suggest that despite all of that, what I just laid out, that we could treat this motion, this appeal, as a motion for permission to file a late appeal. That Reed authorizes that.
That's what Reed did. Yes.
And so essentially, given that, we're not going to overrule Reed, obviously, what we have to decide is whether to exercise that discretion. Agreed?
Sure.
Okay, so tell us why we shouldn't.
Well, if this court did decide to go that route and it was going to decide whether to exercise its supervisory authority and discretion under Practice Book 60-2, subsection 5, to permit a late appeal, then for the reasons laid out in the state's brief, it would suggest that the court not exercise such discretion and not allow the late appeal, because the defendant had utterly failed to show good cause under that practice book section to proceed with a late appeal. The defendant has had myriad opportunities and constitutional, statutory, and procedural mechanisms by which to challenge this allegedly faulty plea canvas well prior to now. And I hear the defendant saying that, well, the issue didn't arise until oral argument on my habeas case when the court brought it up. It's not up to the court to issue spot for the defendant. The faulty plea canvas, if there was one, happened at the time of the plea canvas. The defendant and his attorney were on notice at that moment, unlike in Reed, where several things happened during the plea canvas and subsequent to it that were unforeseen, that neither the parties anticipated or knew about, that the court couldn't have foreseen, and that led to the defendant being deported on a matter that was not supposed to be used for that purpose. That's not what happened here. Everything that the defendant is complaining about happened at the moment of his plea canvas. He knew right then and there. He could have moved to withdraw his guilty plea. He could have taken a direct appeal claiming a constitutional violation. He did file a habeas, and he could have included this claim in his habeas. And he could have filed a subsequent habeas at the moment that the Supreme Court denied certification, instead of saying, well, now because the public defender does it this way, blah, blah, blah. Well, the defendant was on notice at least at that moment when Norm Pattis said he should file a habeas against me. So he squandered numerous opportunities to bring this issue to any court's attention, and instead he tries to circumvent our statutes and rules of practice by waiting until nearly 8 years later to bring a late motion to withdraw that he admits the court had no jurisdiction to hear, and then just takes an appeal from that instead of filing a motion to file a permission for a late appeal to which the state could have objected. And now we're in this very convoluted procedural posture that is nothing whatsoever at all like Reed. In cases where this court or our Supreme Court has allowed late appeals, like in Ramos, the court found that there were exceptional circumstances that were beyond the defendant's control. And in Ramos specifically, the trial court made a mistake on ruling for the petitioner's request for counsel. So the petitioner didn't even know whether he had gotten counsel. And then that caused some sort of confusion in the public defender's office about who, if anyone, was going to handle the case. And so because that was beyond the petitioner's control, the court said, yes, he should be allowed to file a late appeal. But, in other cases, the court has said it didn't rise to an exceptional circumstance. And I would suggest that that's the case here, because the defendant has offered no reason that appears in the record as to why he could not have pursued these myriad remedies at earlier times that would have been much more preferable to making a determination on the merits of this claim. With respect to something that I heard defense counsel state a moment ago, I think in response to Judge Bright's question, with respect to bringing a habeas claim and having to prove prejudice, I disagree with counsel. My understanding is that this is not something that would constitute structural error. The types of plea canvas issues that would arise to structural error are those identified in State versus Gore, which is if the trial court fails to ask to advise the defendant whether he is waiving his right to a jury trial, whether he's waiving his right to confrontation and cross-examination, and those constitutional Boykin requirements that are necessary for a valid guilty plea. When you're talking about some of the other practice book rules in 3919 and 3920, our courts have stated those are more prophylactic in nature, and that if the defendant waits until appeal to raise those, that it is substantial rather than literal compliance. And as the court noted in State versus Ocasio, our Supreme Court had a chance to examine that exact issue. The defendant there claimed that the trial court did not make an inquiry under 39-20 as to whether his plea was the result of force, threats, or coercion. And the Supreme Court said that in that case, substantial compliance with respect to that specific practice book provision, the test is if the court had asked that question, is there any indication in the record that the defendant would have said yes? And looking at the totality of the record, there was no such indication. And that's what you have here. Every question that the trial court did ask was answered in the affirmative by the defendant. He had a chance to talk to his attorney. He understood what the elements were. He understood what he was pleading guilty to. He didn't have any questions for the court. There is absolutely no indication that he was operating under force, threats, or coercion. So, I mean, even the merits of the claim, he could not prevail on. So that's another reason counseling against exercising supervisory authority to permit a late appeal. If you go through that whole kind of a 6-part test almost under the name of the case just went out of my head, but it's cited in both of the parties' briefs for when a court exercises its supervisory authority. But the state's argument would be that this court should not exercise its supervisory authority to permit a late appeal for all of the reasons that I've argued today and that I've laid out in my brief. But I do want to circle back to that I just don't think, based on what our Supreme Court has laid out, that there is jurisdiction for this court to even get to the point where it would think about exercising its discretion to permit a late appeal, just based on what our court has said in Doss and Reed itself. So with that, I will be happy to answer any questions that the court has for me. And if there are none, then we ask this court to affirm the judgment of the trial court dismissing the case. Yes, Your Honor.
Wouldn't you actually be asking us to dismiss this appeal rather than affirming the judgment of the court? Because isn't affirming the judgment of the court exercising jurisdiction over it?
Yes, I'm sorry, Your Honor. I asked for the court to dismiss. I said the wrong thing. I asked for the court to dismiss the appeal in my brief. Yes.
Thank you.
Correct.
And just so I'm clear, didn't you file a motion to dismiss the appeal, or have I got this?
I did not, because we never had the opportunity to do that. This is
procedurally, right.
Yeah, yes. Procedurally speaking, this is actually a timely appeal. So
it is a timely appeal. Yes.
Yeah. So we were kind of deprived of the opportunity to do any of that before it got to this court to begin with, which is part of the problem, I think.
Okay. Thank you.
Thank you for your time, Your Honors.
Okay, Attorney Sexton, you have 4 minutes.
Thank you, Your Honor. I have a couple of very quick points to make, and I'll try to be brief. First, I think that the footnote that Judge Bright, you were discussing with the state actually says that that the Supreme Court said it doesn't have jurisdiction to consider the merits of the claim. It wasn't saying it didn't have jurisdiction to consider whether the trial court had jurisdiction. I think that that's part of what the problem was in the state's analysis of that.
I thought the footnote said did not have jurisdiction to consider the merits of the motion to dismiss.
That it didn't have that is correct, because what had happened in Reed is the state had gone on to consider I believe there was a constitutional exception, and it had gone on to consider whether there was to consider the issue, and then said there was no constitutional violation. And I think what the Supreme Court was saying in Reed is that it can consider whether or not the trial court had jurisdiction, but not to go beyond that. Once it concludes that it didn't, it could not then go reach the merits of the constitutional claim, is how I read that. But I also wanted to point out that I think that in terms of good cause, I think that the good cause analysis is largely subsumed within the exceptional circumstances analysis that's done in supervisory authority cases. And I would point your honors to Justice Norcott's dissent in State v. Reed. He largely relies on the good faith analysis that the court usually does in motions to grant a late appeal as a reason why they should not have invoked their supervisory authority. He was the lone dissenter in that case. I think that the majority did not provide an analysis in terms of responding to him. I think, though, that the one of two conclusions is supported. Either they thought that the good cause analysis was subsumed within the exceptional circumstances, or they thought that as long as you have exceptional circumstances, you didn't need to address good cause. Finally, two final very quick points. The voluntariness is a constitutional requirement. It is, and I would point the court to Brady v. United States, 397 U.S. at 755. It specifically talks about how the court must address the threats, and other voluntariness requirements. It happens to also be codified in 3920, but it is nevertheless of constitutional significance. Finally, I would point out that under Blumberg, if this court believes that we can't succeed on the merits of the claim, and this is at 311 Con 158 and at note 28, Blumberg says that where a party who raised the unpreserved claim cannot prevail, that's another reason to raise it, because it provides finality, it provides the day in court, and there can, of course, be no prejudice to the opposing party. So I think that regardless of whether this court agrees that there is a strong constitutional claim that should be vindicated by using its supervisory authority, or whether it thinks that the defendant can't win, it should nevertheless address the claim and provide some finality to this situation. And that goes to this whole idea. That goes to this whole idea of judicial economy, which Judge Prescott, as you've noted in your treatise, is a reason, and is explicitly enumerated as a reason in 60-3, in order to use your procedural supervisory authority to expedite proceedings in the service of justice. I think if this court provides the analysis, this issue is taken off the table. If it doesn't reach this issue, this is going to resurface again, whether it's, may I just finish my sentence? Thank you, Your Honor. Whether it's in a habeas, on a habeas, or any other procedural posture, this defendant will be back before this court in following years on this exact issue, unless it's put to rest one way or the other. Thank you, Your Honors.
Thank you both. We appreciate you participating through the virtual courtroom. We look forward to seeing you both in the real physical courtroom sometime in the near future. We will take the matter under advisement, and we will stand adjourned until 9:30 tomorrow morning. Thank you.
Thank you, Your Honor.